as CW2 on the 16th of December 2019. He identified and adopted his witness statement on oath filed on the 4th of November 2016, and the additional witness statement on oath filed on the 16th of July 2018. The following documents were tendered through CW2 and admitted by the court. 1. Copy of email dated 5th of August 2012, Exhibit CW2A. 2. The Constitution of the Nigeria Union of Petroleum and Natural Gas Workers, NUPEN, Exhibit CW2B. 3. Collective Bargaining Agreement, Exhibit CW2C. Letter of Termination of Appointment, dated 17th of May 2018, Exhibit CW2D. Solicitor's Letter of Statutes and Shares, dated 26th of September 2014, Exhibit CW2E. Salem University Lokoja Provisional Offer of Admission, dated 26th of June 2012, Exhibit CW2F. Letter of the Federal Ministry of Labor and Productivity, dated 26th of April 2012, Exhibit CW2G. Copy of email dated 15th of March 2018, Exhibit CW2H. Copy of email dated 8th of January 2015, Exhibit CW2J. Copy of email dated 24th of November 2014, Exhibit CW2K. Payment schedule dated 10th of August 2012, Exhibit CW2L. NUPEN letter dated 31st of July 2012, Exhibit CW2M. Copy of email dated 1st of October 2017, Exhibit CW2N. Letter of the Federal Ministry of Labor and Productivity, dated 30th April 2012, Exhibit CW2P. Nigeria Union of Petroleum and Natural Gas Workers, NUPEN letter, dated 25th of April 2012, Exhibit CW2Q. Solicitor's Letter of CC Nzemechi Esquire, dated 30th April 2012, Exhibit CW2R. Solicitor's Letter of the Integrity Law Firm, dated 6th of September 2014, Exhibit CW2S. Solicitor's Letter of the Integrity Law Firm, dated 2nd October 2014, Exhibit CW2T. Charge sheet in charge number PMC/890C/2012, Exhibit CW2U. And the Federal High Court order in suit number FSC/PH/135C/2012, dated 18th of November 2015, was admitted as Exhibit CW2V. The claimant CW2 was cross-examined by the Defendant's Counsel, O.E. Okpala, on the 4th and 30th day of November 2021, as well as on the 5th of April 2022, and discharged without any re-examination. The claimant closed his case on the 5th of April 2022. The defendants opened their defense on the 20th day of February 2023 by calling their sole witness, Samuel Iboji, the administrative and general manager of the first defendant. The witness identified and adopted his witness statement on oath that was filed on the 10th day of January 2023. The following documents were tendered by the defendants and admitted by the court. 1. CTC of complaint in suit number NIC/CA/81/2013, dated 3rd of May 2013, Exhibit DW1A. Letter of termination of employment, dated 1st of May 2012, Exhibit DW1B. CTC of judgment in suit number NICN/CA/81/2013, delivered on the 3rd of December 2015, Exhibit DW1C. Complaint in suit number NICN/YEN/46/2016, filed on the 4th of March 2016, Exhibit DW1D. And CTC of consent judgment in suit number NICN/YEN/46/2016, dated 22nd of May 2018, was admitted and marked Exhibit DW1E. The witness DW was cross-examined by the claimant's counsel, Eso Ibitola on the 20th day of February 2023 and 2nd day of May 2023 and discharged without any re-examination. The defendants closed their case on the 2nd day of May 2023. With the close of evidence in the suit, parties were directed to file their final written addresses. Since the defendants failed to file their final written address within the stipulated period of 21 days, the claimant filed his final written address on the 18th of October 2023. The defendants filed their final written address on the 23rd of October 2023, which was, however, deemed as properly filed and served on the 30th day of November 2023. At the hearing of the suit on the 30th day of November 2023, the learned counsel for the defendants referred the court to the additional authority of Obodo versus Chief Registrar High Court of Lagos State. Citation is given with respect to a claim for defamation before this court. It is pertinent to note that the claimant filed a reply on points of law on the 22nd day of November 2023. These processes were adopted by both counsel on the 30th day of November 2023, with B. Walter appearing for the claimant, while O.E. Okpala appeared for the defendants. The case of the claimant. The claimant pleaded and testified that as a certified radio operator with Global Maritime Distress and Safety System, Accra, Ghana, he was assigned by the first defendant to work on Pacific Border Rig, a drill ship of Pacific International Drilling West Africa Limited that drilled for Chevron Nigeria Limited, Agbami Oil Field in offshore at the coast of Bayelsa State. His main grounds in this suit is that on the 5th of August 2012, the defendants made a publication of a letter dated 3rd of August 2012, which was circulated as an attachment to an electronic mail sent to his colleagues in the first defendant's employment and others unknown. He alleges that the said publication is untrue, libelous, defamatory, scandalous, mischievous, and malicious to his person and office. He pleads further that subsequent to the publication, the branch executive of his union was dissolved and he was invited to a mediation meeting with the Federal Minister of Labor, where himself and other executive members were arrested and handcuffed by the police. They were detained for 3 days before their appointments were terminated without pay. He could no longer cater for his family as his daughter, who secured admission to Salem University, Lokoja, Kogi State, would not go to the university due to his inability to pay the school fees. The 2 criminal cases instituted against him, both at the Chief Magistrate Court 1, Port Harcourt, and the Federal High Court, Port Harcourt, both ended in his favor. According to the claimant, despite the letters from the solicitors asking the defendants to retract the publication and publish an unreserved apology, they have failed, refused, and neglected to do so. He pleads the particulars of malice to include: 1, he is a well-experienced radio operator certified by the Global Maritime Distress and Safety System, Accra, Ghana, and worked in one of the biggest rigs in the world. 2, he was the chairman of the first defendants branch of Nigeria Union of Petroleum and Natural Gas Workers, NOPEN. 3, the source of the stories are fictitious and not ascertainable and were not proved during series of meetings. 4, the defendants failed to produce the CCTV recordings, video, and photographic proof to buttress the allegation against the workers laid by the claimant. 5, the stories were based on speculations and circulated to more than 100 people, including organizations aimed at humiliating the claimant. 6, there is no provision in both the Trade Dispute Act, the Union Constitution, and the First Defendants Collective Agreement prescribing termination as a penalty for embarking on strike. 7, while other workers were paid their terminal benefits by the first defendant, the claimant's benefits were not paid. 8, the first defendant wrote a petition to the Rivers State Commissioner of Police dated 30th of April 2012, which led to the arrest of the claimant and others. That since his reputation and character have been smeared or damaged, he is entitled to the reliefs in the suit. Now, defendant's case. The defendants aver that while the claimant worked with the first defendant from November 2010 to 1st of May 2012 as a radio operator, the letter of 3rd of August 2012, which the claimant alleged has defended his character, was written as a reply to a letter addressed to the first defendant by the Nigerian Union of Petroleum and Natural Gas Workers, NUPEN, relating to the conduct of the claimant and others, which led to the crisis at the claimant former workplace, that is the Pacific Bora. That prior to the letter of 3rd of August 2012, NUPEN, through Comrade Chinda W. Ajims, the zonal secretary, had written to the claimant, notifying him of his removal as a union member / officer, and condemned his actions on board the Pacific Bora from 25th to 29th of April 2012. The defendants denied publishing the letter of 3rd of August 2012 to any person or third party, except those who were also copied with the originating letter. According to the defendants, the claimant had filed suit number NICN/CA/81/2013, challenging the termination of his employment by the first defendant, and the suit was struck out via judgment delivered on the 3rd of December 2015. He thereafter filed suit number NICN/YEN/46/2016, also challenging the termination of his employment by the first defendant, and a consent judgment was entered on the 22nd day of May 2018. That the court lacks jurisdiction to entertain the suit because the subject matter of the suit, being one of defamation, is not within the contemplation of Section 254C1A to M of the 1999 Constitution as amended, and the suit is an abuse of court process. The court was urged to dismiss the suit. Now, claimant's submissions. The learned counsel for the claimant submitted these 3 issues for determination. 1, whether the National Industrial Court exercises jurisdiction to entertain the suit as the subject matter deals with the allegation of defamation. 2, whether exhibits published on the authority of the defendants defamatory of the claimant, having regard to the pleadings and evidence. And 3, whether the claimant is entitled to aggravated and general damages. The claimant submits on issue 1 that by a community reading of Section 7 sub 1A of the National Industrial Code Act and Section 254C1A of the 1999 Constitution as amended, this court has jurisdiction to entertain the subject matter of this suit relating to defamation at the workplace. That this is the position despite the decision of the Court of Appeal in the case of Dr. Emmanuel Akpan versus University of Calabar, that defamation arising from an employer-employee relationship is not a matter within the competence of the National Industrial Court of Nigeria. See also Kafo versus Ekianyi and others relating to the element of proof in tort of defamation. That since the claims in this suit relate to defamation simplicity and not lumped together with any claim bordering on termination of employment, the case of Akman versus University of Calabar is inapplicable to this suit. It was further argued that since the decision of the same Court of Appeal in the case of Medical and Health Workers Union of Nigeria versus Dr. Alfred Ehigioba, citation is given, held that the tort of defamation arising from workplace relationships is within the exclusive jurisdiction of this court, is later in time, it should take precedence over the decision of the same Court of Appeal in Akman versus University of Calabar. Counsel referred to Alao versus Vice Chancellor, University of Ilorin, Adigun versus Ayinde, Central Bank of Nigeria versus Zakari, or Sakwe versus Federal College of Education. All citations are all provided. The court was urged to resolve issue 1 in favor of the claimant. With respect to issue 2, it was argued that having regard to the pleading and evidence on record, the claimant has shown that Exhibit CW1B, which is attached to Exhibit CW1A, published by the defendants, is defamatory or libelous of the claimant. The publication in libel matters means the making known of the defamatory statement to some persons other than the persons to whom it was written about. That a claimant in an action for defamation must establish the following: 1, publication of the offending words by the defendant. 2, that the words complained of refer to the claimant. 3, that the words are defamatory of the claimant. 4, publication to third parties. 5, falsity or lack of accuracy of the words complained of. 6, that there was no justifiable legal grounds for the publication of the words. The court was urged to resolve issue 2 in favor of the claimant. Counsel referred to the cases of Dr. Jeremiah O. Abalaka versus Professor Ibironke Akinshete and 2 others. Citation is given, as well as Nsirim versus Nsirim and Salau versus Makinde, as well as Omoajeje versus Ogbojafo. Citations are all provided. On issue 3, the legal counsel for the claimant posited that having proved that the defendants are responsible for the libelous publication, the claimant is entitled to award of aggravated and general damages which are presumed by law and flow naturally from the proved defamation or libel. Counsel referred to the cases of Chief Tony Okoroji versus Onyenka Owenu, Ashek versus MT Nigeria Limited, Oduele versus West, Guardian Newspapers Limited versus Ajay, and Benue Printing and Publishing Corporation versus Wagwada. Citations are all given. Learned counsel referred to Exhibit CW1A and CW1B, as well as CW2A to CW2N, and argued that the claimant has proved his claims before the court and is entitled to the relief sought in the suit. It was further argued that Exhibits DW1A to DW1E were merely dumped on the court by the defendants, that the defendants failed to properly plead estoppel in their pleadings, referring to the case of Gwemisola versus Bolarinwa. Citation is given. That apart from the fact that Pacific International Drilling West Africa Limited was not a party in suit number NICN/YEN/46/2016, that is Exhibit DW1E, the claims and parties in Exhibits DW1A, DW1C, and DW1E are the same, and the decision in Exhibits DW1A and DW1C are not final because the suit was merely struck out and not dismissed, that the plea of estoppel parem judicata does not arise in this suit because the cause of action in this suit, which is the defamation of character, has not been distinctly put in issue and has not been determined directly and with certainty in Exhibits DW1A, DW1C, DW1D, and DW1E, that the ingredients of a successful plea of successful plea of estoppel parem judicata must include the following: A, the parties or their previous are the same; B, the facts in issue in both the previous litigation and the present one are the same, that the same question was decided in the earlier proceedings. C, the subject matter of the claim is the same. 4, the decision relied upon to support the estoppel parem judicata must be final, and E, the court giving the decision is a competent court. The court was all to resolve issue 3 in favor of the claimant and enter judgment in his favor. Defendant's submissions. The defendant's counsel identified the following 2 issues for the court's determination. 1, whether this honorable court is properly clothed with the requisite jurisdiction to hear and determine the case of defamation as brought by the claimant. 2, having regard to the pleading and the evidence before this honorable court, has the claimant proved the case of defamation as required by law to be entitled to judgment in his favor. It was submitted on issue 1 that having regard to the pleadings and evidence on record, this honorable court lacks the jurisdiction to entertain this suit, that a claim is circumscribed by the release before the court, referring to the case of Gabriel versus Kabe Meta. It was further argued that for a court to have jurisdiction to determine a matter, the following must be met: the court is properly constituted as regards members and non-members, as regards number and qualification of members, and non-member is disqualified for one reason or the other. The subject matter of the case is within the jurisdiction of the court, and there is no feature in the case which prevents the court from exercising jurisdiction. The case comes before the court initiated by due process of law and upon fulfillment of any condition precedent to the exercise of jurisdiction. Counsel referred to Madukolu against Kemdilim. It was further posited that while the position had been that this honorable court had no jurisdiction to entertain defamation cases, recent decisions, however, tend to show that this court has jurisdiction to determine cases of defamation in an employer-employee relationship in the workplace, that the employee must show that the defamation occurred during the subsistence of the employment relationship. A former employee cannot therefore bring a defamation claim before this honorable court. Counsel referred to Dr. Emmanuel Akman, West University of Calabar, Medical and Health Workers Union of Nigeria versus Dr. Alfred Ehigeba, Union Bank of Nigeria PLC versus Igbo, and LMA Petrochemicals Company Limited against Asonye. The learned counsel to the defendants referred to Exhibit DW1E and submitted that the claimant had filed multiple suits against the first defendant, and while the judgment in suit number NICN/CA/81/2013 was delivered on 3rd of December 2012, the consent judgment in suit number NICN/YEN/46/2016 was entered on the 22nd of May 2018. That since by the terms of settlement, the claimant accepted that his employment was terminated on the 1st of May 2012, by the 5th of August 2012, when the purported defamatory material was made, the claimant was no longer in the employment of the first defendant. Hence, there was no employer-employee relationship between him and the first defendant. The court was called to resolve issue 1 in favor of the defendants and decline jurisdiction in the matter. With respect to issue 2, it was posited that to succeed in an action for defamation, the defended person must conjunctively establish the following ingredients: 1, publication of the offending words; 2, that the offending words refer to him; 3, that the offending words are defamatory of him; 4, that the offending words were published to a third party; 5, that they were false or lack accuracy; and 6, that there are no justifiable legal grounds for the publication of the defamatory words. Counsel referred to Omika versus Issa. Citation is given. According to the defendants, it was equal to Exhibit CW2Q, written by the Nigerian Union of Petroleum and Natural Gas Workers, wherein the union deprecated and condemned in strong terms the actions of the claimant and his secretary, who testified as CW1 in the suit, and the letter of the Federal Ministry of Labor and Productivity, Exhibit CW2G, that the first defendant replied to Exhibit CW2Q, stating the facts as they were, that since it was the claimant's union that referred to him as a man who led an uprising, who has no regard for the rule of law, any statement made or written against anyone which is true cannot be defamatory, as a statement is defamatory only if it is false and without justification. Counsel referred to Sketch Publishing Company versus Ajegbero Keferi and Esenowo versus Pukon, as well as Odotin versus Mogaji. Citations are all given. That by Exhibit CW2Q and CW2G, the claimant lacks the reputation he seeks to defend and enforce because he failed to state his position, status, or station in life, and the reputation he built over the years that he wishes to protect. Reference was made to the additional authority of Obodo versus Sia High Court of Lagos State. Citation is given. The court was urged to resolve issue 2 in favor of the defendants and to dismiss the suit with cost. Claimant's reply on points of law. It is pertinent to note that the claimant filed a reply on points of law on the 22nd of November 2023. It was argued that since the defendants referred to cases without citations, the cases referred to should be discountenanced. Counsel referred to Alpha versus Atai. Citation is given and order 45 with 2 sub 2D of the rules of this court 2017. That the case of Medical and Health Workers Union of Nigeria versus Dr. Alfred Supra, cited and relied upon by the defendants, has no correlation with this suit because it had nothing to do with employer-employee relationship. It was further replied that since the defendants witness DW1 testified that he published exhibits CW1B and CW2A, such a statement amounts to an admission in law that a publication in a libel suit is a making known of the defamatory statement to some persons other than the persons to whom it was written about. Counsel referred to Nsirim versus Nsirim, Salawo versus Makinde, and Agege versus Ogojafu, Supra. That since the allegations against the claimant at both the Magistrate Court and the Federal High Court were not established, the defendant's defense of justification is of no moment. With respect to the defendant's contention that Exhibit CW1A and CW1B did not comply with Section 84 of the Evidence Act, it was applied that proof under Section 84 of the Evidence Act can be either by oral evidence under Section 84.1 or by a certificate under Section 84.2. Counsel referred to Dixon versus Silva and Kubo versus Dixon. Citations are both provided. That proper foundations were laid before Exhibit CW1A and CW1B were tendered and admitted by the court. the court was out to grant the reliefs in the suit. Now, cost judgment. After considering the pleadings, evidence, and submissions of both learned counsel to the parties, I am of the view that the suit can be determined on the basis of these two issues. One, whether this honorable court has jurisdiction to hear and determine this suit. And two, whether from the facts and evidence laid before the court, the claimant has proved his case to entitle him to the relief sought against the defendants. Since issue one challenges the jurisdiction of this honorable court to entertain the suit, the court shall first determine the issue of jurisdiction in view of its importance to any proceeding before the court. See Mr. Alalade of Hydra Agency Nigeria Limited and others versus the presiding president of the Ota Grade 1 Customary Court and others, as well as National Air Care Center versus Dr. M.E. Asuku and others. Citations are provided. I have seen that the contention of the defendant's counsel on this issue is not strictly speaking that this honorable court has no jurisdiction to determine this suit. In fact, both counsel are in agreement that this honorable court has jurisdiction to entertain cases relating to defamation going by the recent decisions of the Court of Appeal, particularly the cases of Dr. Emmanuel Akman, University of Calabar, and Medical and Health Workers Union of Nigeria versus Dr. Alfred Ehi Iagba. The only area of divergence between both counsels is the contention of the defendants that for this court to have jurisdiction over cases of defamation, the alleged act of defamation must occur in an employer-employee relationship at the workplace. That since the alleged defamatory act complained of by the claimant occurred on the 5th of August 2012, after the claimant had resigned his appointment on the 1st of May 2012, there was no subsisting employment between the parties when the defamation allegedly occurred. This contention of the learned counsel to the defendants is in tandem with the provisions of Section 254C1 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and Section 7 of the National Industrial Code Act 2006. I have seen from the pleadings and the evidence on record that the case of the claimant is anchored on Exhibit CW2B, dated 3rd of August 2012, which was allegedly published by the defendants on the 5th of August 2012, and also that the claimant's employment ended on the 1st of May 2012 via Exhibit DW1B, signed by Joan Esuku, the first defendant human resource coordinator. While it would seem that when the alleged defamatory publication was made, the claimant has ceased to be an employee of the defendant, I have however seen on record that the defendant issued another letter of termination of employment dated 17th of May 2018, Exhibit CW2D, to the claimant, signed by Samuel A. Iboji, the first defendant human resources manager. It is obvious that there is a huge cloud surrounding the date the employment of the claimant ended with the defendant in view of the conflicting dates in the exhibits DW1B and CW2D. Was the claimant reabsorbed into the employment of the defendant after the issuance of exhibit DW1B to him and subsequently disengaged via exhibit CW2D? None of the parties has given any explanation to this. I therefore hold a considered view that the justice of the case will be better served if the doubt is resolved in favor of the claimant. It will therefore be speculative for the court to take the position that when the alleged defamatory publication was made, the claimant had ceased to be an employee of the defendant. Issue 1 is therefore resolved in favor of the claimant, and the court hereby assumes jurisdiction in the matter. It may also be apposite to resolve the other leg of the objection to the jurisdiction of this honorable court, raised by the learned counsel to the defendants, that the instant suit is an abuse of court process because the claimant had instituted suit number NICN/CA/81/2013, which judgment was delivered on the 3rd of November 2015, and also suit number NICN/YEN/46/2016, which consent judgment was entered on the 22nd of May 2018. I have looked at the parties and the reliefs in the previous cases instituted by the claimant, as can be gleaned from exhibits DW1A, DW1C, DW1E, and DW1D, and seen that while the cause of action in those cases related to termination of employment and claims for terminal benefits and arrears of other entitlements, the claims in this suit are strictly with respect to damages for defamation. Since both the parties and the causes of action or subject matter of the cases are not the same, I hold a considered view that the instant suit is not an abuse of court process. Having assumed jurisdiction in the matter, the court shall now proceed to consider issue 2 relating to the substantive suit before the court. With respect to issue 2, let me state that having gone through the claimant's pleadings, including the reliefs in the suit and the evidence on record, it is clear that the suit is hinged solely on Exhibit CW2A, by which the defendants allegedly published Exhibit CW1B, which the claimant is alleging has defamed his character and person. It may therefore be apposite to reproduce the alleged defamatory statement in the Exhibit CW1B for the purpose of clarity. 3rd August 2012, the Zonal Chairman, Nigeria Union of Petroleum and Natural Gas Workers, Port Harcourt Zonal Office, 35 Okoroji Street, behind Olu Obasanjo Police Station, D-Line, Port Harcourt, Rivers State, Nigeria. Dear sir, termination of our members, 7 days ultimatum. We are in receipt of your letter dated 31st day of July 2012 with the above subject matter and strongly compelled to respond to same as a result of clear misrepresentations and misleading contents of the said letter. We wish to put the record straight as follows. 1, that the incident on the Pacific border that took place from the 25th to the 29th of April 2012, apart from the unlawful strike action called by the masterminds, both onshore and offshore, also involve acts of criminality, which involve harassment of both expatriate and fellow Nigerian employees, violence and threatening violence, hostage taking, and use of mechanized fire extinguishers to block the helideck in an attempt to set the rig on fire in the event that a helicopter were to land to evacuate people from the rig. 2, that the Nupeng Zonal Council took the proper step by denouncing the action of the said workers in this letter dated 25th of April 2012, where it clearly dissociated itself from any consequences or uprising that may be a fallout of the illegal and criminal strike action. See attached. 3, that after the resolution of the impasse resulting from the unlawful strike action, the management of KJ Energy and Nupeng Zonal officials had meetings on the 11th and 21st of May 2012 to resolve all outstanding issues surrounding the incident of 24th of April to 29th of April 2012, with each party conducting its own independent investigations. 4, that the termination instead of dismissal of affected employees were based on factual evidence of their involvement, both in the planning and the execution of the actions, which was rightly condemned by the union as being contrary to the letters and spirit of the CBA and as constituting willful insubordination and gross misconduct. 5, that Nupeng and management after the meetings of 11 and 21st May at the Hotel Presidential Port Harcourt were on the same page as to the action to be taken against erring workers who were identified to have played parts in the several illegal actions that took place. The violent conduct of the affected workers were firmly established by the vessel management team and interview of workers who reported acts of harassment and violence against them. 6, that the pending criminal cases in court, that is charge number PMC/8906/2012, COP versus Pochike and 6 others, and charge number FSC/PH/135C/12, COP versus Pochike and 6 others, both have charges of conspiracy with persons at large included, who are all part of the 11 persons already terminated, but indicated in your letter as penciled down for termination. It is rather disheartening, to say the least, that Nupeng PHC Zone will resort to half-truths and misrepresentations to denounce discussions and resolutions reached in meetings held, as aforesaid, on the ground that the minutes were not signed, knowing quite well the management views such meetings and resolutions reached as that emanating from men of honor and integrity. The management of KJ Energy wished to reiterate that none of its employees were unjustly terminated. All the workers arrested at the state meeting were involved in the planning and execution of both Chike's-led criminal actions. The employees who had their employment terminated were active participants in the illegal and criminal actions and conspiracy that took place both onshore and offshore. We wish to emphasize that we stand by the resolution of the dispute and disagreements on the subject matter by the Federal Ministry of Labor based on the complaint laid by your union, NUPEN, and the pronouncements made thereon on the 24th of July 2012 by the federal government through the ministry, upholding the terminations. The CBA we have with NUPEN is clear on what constitutes grounds for redundancy, and this is not one of such grounds. It is in the light of the foregoing facts and matters that we find your ultimatum misplaced and ill-advised, and urge you to use your good offices to reconsider your position, as same does not represent the spirit and the assurances given to the management at the inception of NUPEN in our company, that NUPEN will always abide by the rule of law and always follow the path of truth and justice in safeguarding our investment and that of our client in our operations. We have thus far enjoyed a good relationship with NUPEN before this unfortunate distraction by a few misguided and disgruntled elements. The union should realize that KJ is one of its fruitful farms, which generates immense revenue to the coffers of NUPEN. NUPEN is duly bound to protect the KJ/PIDWAL operations, which provides lucrative employment to over 200 Nigerians. We cannot disrupt the livelihood of the majority for a minority few who chose the wrong path. We urge wise counsel to prevail to enable us to explore the middle ground to save land and get rid of this issue in the overall interest of industrial peace and harmony. Yours faithfully, KJ Energy Services Limited, Chris Roberts, MSc. It may be pertinent to point out that the only portion of Exhibit CW1B reproduced above, which the claimant finds offensive, is the paragraph at page 2, that states as follows, and I quote, "The management of KJ Energy wish to reiterate that none of its employees were unjustly terminated. All the workers arrested at the said meeting were involved in the planning and execution of Portuguese-led criminal actions. The employees who had their employment terminated were active participants in the illegal and criminal actions and conspiracy that took place both onshore and offshore." End of quote. This is the statement or publication he is alleging that has smeared and disparaged his reputation and character, which made him to suffer considerable disgrace, financial loss of good jobs, and embarrassment. It is good to make the point that the onus of proof is squarely on the claimant, who has alleged that the defendants have disparaged his character and reputation. This position is in line with sections 131, 132, 133, and 134 of the Evidence Act. See the case of Tuku Amadu and another, Mrs. Nasai Meyongo, and another. Citation is given where the Court of Appeal held, and I quote, "The law on the burden of proof in civil matters and the standard of proof required is settled. The plaintiff or claimant in a civil case has the burden to prove his case on the balance of probability, depending on the strength of his case and not on the weakness of the defendant's case." See PDP versus INEC, Ndru versus Wayo, end of quote. See also Alaji Raji, Oduola, and others versus John Badogo Koka, and another. Citation is also given. What then are the ingredients of the tort of defamation the claimant is required to establish to be entitled to judgment? The answer to this puzzle can be found in a plethora of cases, including that of Dr. Jeremiah O. Abalaka versus Professor Ibironke Akinshete and others, where the Apex Court for Ogunwumeju, JSC, held as follows at pages 20 to 25, paragraphs G to F of the report, and I quote, "Apart from the proof of publication of defamatory words in the claim for damages, the claimant must prove that the words referred to him and that they are in fact defamatory in the sense that they are untrue or false. It seems to me that the jurisprudence in Nigeria is that justification or the truth can be both a sword and a shield. See Guardian Newspapers Limited versus Ajay, Sketch versus Ajagbe Mokeferi. In Sketch versus Ajagbe Mokeferi Supra, the court per Abubakar Bashir Wali JSC held inter alia thus in an action for defamation, the onus is on the plaintiff to prove that the words complained of conveyed a defamatory meaning to whom they were published, end of quote. In Eloabachi versus Eloabachi, Akinton JSC said at page 695 of the report as follows: the onus is on the plaintiff in an action for libel to show that the published words complained of are defamatory or that they convey a defamatory imputation. However, where the words complained of are defamatory in their natural and ordinary meaning, the plaintiff has no legal duty to lead any evidence to show additional defamatory meaning as understood by persons possessing some particular facts. The court below held as follows on page 155 of the record. The appellant claimed that he has found a vaccine to cure HIV/AIDS. The third respondent, a retired soldier living with HIV, used the said vaccine, and according to him, he is still HIV positive. The third respondent also gave the statistics of 30 soldiers who have used the vaccine, and some, according to them, are dead, while others are still living with HIV. His assessment, therefore, is that the cure is not effective, and that the appellant and other persons who parade themselves as having found a cure for HIV are liars and cheats. The onus is on the appellant to prove that these statements purportedly made by the respondents are false. My lords, the Court of Appeal in Otop versus Ekon held thus: if a statement complained of appears to be derogatory or disparaging or injurious to a person so as to impeach his character or reputation, it may still not amount to defamation unless the party or person complaining proves that it was false statement. In Ekon versus Otop and others, the court par Umay Bayan Akas JSC held as follows: in an action for libel, the plaintiff must prove: 1, the defendant published in permanent form the statement which the plaintiff complains of as defamatory; 2, that the statement was false; 3, that the statement referred to the plaintiff; 4, that the statement conveys defamatory meaning to those whom it was published; and 5, that the statement was defamatory of the plaintiff in the sense that A, it lowered him in the estimation of right-thinking members of the society, or B, it exposed him to hatred, ridicule, or contempt, or C, it injured his reputation in his office, trade, or profession, or it injured his financial credit. See Sketch Publishing Company Limited versus Ajagbemo Keferi Supra, Ofoboshe versus Ogoja Local Government, Guardian Newspapers Limited and another versus Reverend Pastor C.I. Ajay. See also Sule and others versus Orisa Jimmy. Chike Security Services versus Slumberger Nigeria Limited and another. This court held that all these authorities are unanimous that such a plaintiff can only be entitled to judgment if he proves that the defendant, 1, published a statement in permanent form; 2, that the statement referred to him; 3, that the statement was defamatory of his person in the sense that A, it lowered him in the estimation of right-thinking members of society; B, exposed him to hatred, ridicule, or contempt; or C, injured his reputation in his office, trade, or profession; or D, it injured his financial credit. In SCB Limited and others versus Apugo, this court by Ejiwumi JSC held at page 483 of the report as follows: earlier in this judgment, reference was made to the binding principle governing obligations of a plaintiff and a defendant in an action in defamation, particularly whereas in the instant case, the defendant is pleading justification as his defense. The principle in this kind of cases, if I may repeat, is that where a plaintiff has established that he was defamed by words published or caused to be published by the defendant, the onus lies on the defendant to prove the truth of the words so published. It seems to me that this court is moving from the position that the onus shifts to the defense, where the plaintiff has proved the publication of the defamatory words and also proved that his reputation has been adversely affected by the position that the onus is on the position that the onus is on the plaintiff to also prove the falsehood of the publication. Similarly, in Awolowo versus Kings West Stores and another, the court held entirely that a statement does not give rise to a cause of action merely because it causes damage to the plaintiff. The statement must be false, and it must also be defamatory of the plaintiff. It seems that there are two opinions of this court regarding who bears the onus of first proving whether a publication is false. It seems that in SCB versus Apugo, this court held the view that the law presumes defamatory words to be false in the plaintiff's favor once the plaintiff establishes he was defamed. This court also held that justification, fair comment, or the proof of the truth is, however, a complete defense. The onus of proof is on the defense to prove that the main gist is true. End of quote. I have seen that the pleadings and evidence on, I have seen from the pleadings and evidence on record the alleged defamatory letter, Exhibit CW1B, was addressed to the zonal chairman of NUPEN, Port Harcourt zonal office, and actually copied to other 10 organizations, aside from the several email addresses as can be gleaned from Exhibit CW1A. The said publication is a response to the letter of the Port Harcourt zonal office of NUPEN dated 31st of July 2012, which is in evidence as Exhibit CW2M. The defendants are placing reliance on Exhibit CW2G, CW2M, and CW2Q to argue that since both the Claimants Union and the Federal Ministry of Labor and Productivity condemned the actions of the claimant and his union executives and declared the strike action called by the union as illegal and an uprising, which led to the dissolution of the branch executives of the union in the first defendant, the defendant's statement in Exhibit CW2B is not false and without justification to make the defendants liable for defamation. I have called over the said Exhibit CW2G, CW2M, and CW2Q, and I did not see where those exhibits describe the claimant the way the defendants did in Exhibit CW2B. While it is true that the strike action was condemned and declared illegal, and the union branch executive of the union in the first defendant, led by the claimant, was dissolved, nowhere was the claimant described as a criminal and hostage taker. The union, NUPEN, only dissociated itself from any uprising as a result of the strike action, without more, to have warranted the language used on the claimant in Exhibit CW2B. Exhibit CW2B clearly mentioned the claimant by name as the leader of the criminal actions and conspiracy that took place both onshore and offshore, which involved harassment of both expatriate and fellow Nigerian employees, violence and threatened violence, hostage taking, and use of mechanized fire extinguishers to block the helideck in an attempt to set the rig on fire in the event that a helicopter were to land to evacuate people from the rig. In fact, Exhibit CW2R, addressed to the Commissioner of Police, Rivers State Police Command, also lists the claimant as one of those who hijacked the rig, blocked access to the helipad by placing big fire extinguishers so as to cause explosion in the event a helicopter lands on the helipad, threatened the life and person of several staff on board the rig, and as a result of the hostage situation, 3 expatriate staff who were due for crew change and had family emergencies had to be deployed out of the rig by means of an emergency basket onto a boat that took them to another platform from which they boarded a chopper to be able to exit the rig. The point being made by the court is that having reported any alleged criminal action associated with the strike action, the defendants should have waited for the police to conclude their investigations and, where possible, charge the matter to court for criminal findings, rather than refer to the claimant the way they did in the Exhibit CW2B, which was no doubt communicated to other persons, including his union members and co-workers. There is clearly no justification for the statement in Exhibit CW2B, and considering the serious nature of the words used in the statement, the defendants, who have the burden to justify same, have failed to do so. They allege that they have documents, photographs, and CCTV footages of the incident, but failed to produce them before the court to assist the court in ascertaining the extent of the actions of the claimants and his colleagues on the rig, that is the Pacific Borer. I have also seen from Exhibit CW2U and CW2V that even though the claimant was charged before both the Magistrate Court Port Harcourt in charge number PMC/890C/2012 for conspiracy, embarking on an illegal strike and engaging in acts that endanger lives, the charge before the Federal High Court with number FSC PH/135C/2012 was struck out for want of diligent prosecution on the 18th of November 2015, as the accused persons, including the claimant, did not even take their pleas. Since there is no judicial pronouncement on the criminal allegations against the claimant, the statement of the defendants is clearly uncalled for, and there cannot be any justification for that. It is obvious from Exhibit CW2J, CW2K, CW2H, and CW2N that the claimant's profession suffered as a result of the publication of the defendant's statement in Exhibit CW2B, which affected his chances of securing another employment. While from Exhibit CW2K, CW2H, and CW2J, the claimant concluded job interview with death wish. He was, however, described in Exhibit CW2N as, quote, the guy was a major player in the first shutdown of Pacific Borer, end of quote. There is no indication that the claimant secured the job after the description in Exhibit CW2N. In the final result, I find merit in the case of the claimant. Issue 2 is hereby resolved in the claimant's favor. The suit succeeds, and the court hereby makes the following orders. 1, the sum of 10 million naira is hereby awarded to the claimant to be paid by the defendants as aggravated and exemplary damages for the libelous words maliciously published against the claimant by the defendant. 2, the defendants are hereby ordered to tender an unreserved apology in writing to the claimant for the said publication. And 3, an order of perpetual injunction is hereby made, restraining the defendants either by themselves, agents, privy servants, or through any means whatsoever from publishing or disseminating the said libelous and defamatory words concerning or relating to or connected with the claimant or his profession, or in any way whatsoever or howsoever. The terms of this judgment shall be complied with within 30 days from today, failing which it shall attract interest at 10% per annum until it is fully liquidated. Judgment is entered accordingly, and I make no order as to cost.
As the court pleases, my lord. My lord, that was a detailed and a well-researched judgment. We are grateful for my lord's serious work put into this judgment.
Thank you, Opala.
Though the judgment did not go in our favor, but it opened up a lot of judicial areas that are very interesting. My lord, I enjoyed the judgments my lord cited. Lord, we'll look at the judgment and advise our client accordingly.
Thank you. So today is Friday. You will have copies next week.
Yes, my lord.
All right.
Yes, my lord. Yes,
all right. Thank you. Have a nice weekend.
Yes,
Bye-bye.